Hi everyone, Kerri Glover here. Just going to share more information about how you can create contracts with confidence, the elements that you need in your contract for your business that can protect your home and family. So let's dive in and get started. It's really important that you have a strong contract. It will protect your family, it will protect your business, it will protect your property. So let's get confident in that and understand what the elements are that are important to have. Here's my legal disclaimer. I am a licensed attorney with the Bar of the District of Columbia, but I'm not your attorney. So please seek counsel when you're drafting your agreement to review it. I'm available to draft your contracts for a flat fee. I'm very affordable. This is the reason I went back to law school, is to help small businesses protect themselves from liability. And my legal statements that I make here in this video are very general, but they widely can vary by jurisdiction. So let's talk about the big picture. Your contract is the protection in the worst case scenario. I had a great law school professor who always taught us that you are human first, but your contract is designed for the absolute worst case scenario. So even though you have these terms outlined in your contract, if you make a decision as a business owner to be more lenient than your contract allows, that's your decision. You're humans first, be a human first, rely on your contract only in the worst case scenario, and make that human decision before you have to lean on your contract. And remember, if you know your contract well and you understand it well, it's a great marketing tool. If you have a strong contract, you want to be well versed in the language and use it to sell to your clients. Understand that you've invested in protecting the both of you, and then use that as a marketing tool that it is. So let's start at the beginning. You want to understand exactly what all the terms are in the contract. So to make sure that you clearly define who the parties are, what the elements are of the contract, at the very beginning of the contract, it should define who the legal terms are. So this presentation specifically has been written for wedding venues, but of course it can be varied just based on your business type. So you want to clearly outline what your legal business name is, and then you define that term as the venue for the rest of the contract so that you don't have to write out your entire full name of your company throughout the contract. Your client name should be the client, again, capitalized. Make sure that you're defining those legal terms with capitals. Your property, if your business has a location, it could be the property. In this case, we're talking about a licensing fee when it comes to the property because that's the nature of what a wedding venue is. But you also should determine, your business property, and if you welcome clients to it, that should be determined in the contract as well. If you are a wedding venue, you want to make sure that the event date is termed to as event, so that can also be referred to many times in the contract. Make sure you use these terms throughout the contract so it's very clear what you're referring to and in which clause. So let's just talk very high level. What is a contract? There are basically three elements of a contract. There's the offer, where you extend the contract to your potential client. That is an offer of performance there. If they accept it, meaning they sign the contract, that's acceptance. And then the third piece is consideration. Now, this is kind of a funny thing. It's really the money exchanging hands, as we come to know. But in most jurisdictions, consideration can be anything. It could be something simple as a candy bar pushed across the table. Once an offer has been extended, that offer has been accepted, and the candy bar is pushed across the table, you have a contract. Now, the only element that's left in the contract is your duty to perform. There's a performance based on that offer that you are required to do. If you are a wedding venue, that means that you have given a license to your venue on the dates, the event dates that you have offered. Taking that date out of inventory is the performance of your contract. And it's very important that you understand that it's a wedding venue. So the actual performance is not showing up on wedding day and being amazing, rolling out tables the way that they want you to, moving the ceremony when it rains. None of that is performance. The actual performance of your contract is truly the reservation of the event day and taking that inventory date out of inventory to be sold or offered to other clients. Let's talk a little bit about the terms of the contract. So the license is the legal term when you're offering your clients. It's a temporary, limited, and it's defined to have direct access to your property. What you owe as a licensee is access to your property at designated times and the safety of your property for natural and man-made hazards. So that means that once legally, if you allow a licensee to have a license to your property, to have access to your property, that legal definition of your relationship means that you need to make sure your property is safe from natural, meaning like sinkholes, hole in the ground, crazy animals, and or man-made hazards. So you've dug a hole, you've created a man-made hazard. That's really important to know that that is also something you need to protect those clients from. Everything else that you've added in the contract, those are your terms. So including the inventory list, any additional services, those are terms every time that you add those elements to the contract that are part of those elements. So if you're including, inventory that's to be included, understand that that becomes part of that performance. And also include overtime charges. Make sure that that's very, very clear in your contract, that if it extends past the license as determined legally, that there's clear definition about what that would cost the client in order to extend that license. If there's additional services, make sure that the information in the contract is very clear, it's definite, and it's up to date with your actual inventory at the venue. I know as a business owner myself, a wedding venue owner myself, we often add inventory and remove inventory, and it doesn't come to the front of mind to say, well, we have now 10 6-foot tables instead of 8 6-foot tables, and to update that inventory in your contract. If there are additional costs associated with additional services, make sure the costs are clear and also have payment terms that are very clear in there as well. Let's talk about money a little bit. Make sure that your payment terms are very clear in your contract, not only when they're expected, by what date and how those are determined, but what happens if those things run late. The biggest mistake that I see wedding venues make, or actually a lot of types of services businesses, is that they do a big 50-50 split. So they'll take a huge deposit up front and a huge deposit right before the event, or before the end of the performance, or sometimes after the performance if you're a services venue. This causes quite a few problems. One, it's more difficult to market because you have such a big deposit up front. I shouldn't say deposit, reservation fee up front for your services. It's a bit harder to sell because maybe it's a little tougher on the cash flow. It's easier to sell with a smaller fee up front. So typically I recommend 20 to 25% down. We call this a reservation fee, not a deposit. A deposit in legal terms implies future performance instead of a reservation fee, which shows the performance is happening immediately upon acceptance and consideration of this contract. So if you say there's a reservation fee and this person pays the reservation fee, your active performance of taking that date out of inventory, your performance is complete. And that's very important. And what the biggest things that happened during COVID with wedding venues is they had a lot of contracts that said deposit. Well, when they were pulled into court, all the judges were saying, well, deposit implies future performance. And so because you can't perform because of COVID, you need to return these fees. If those contracts had said reservation fees, the judges would have had to apply the legal definition of that and seen that the performance of that had already taken place once the contract was signed and the date was taken at reservation. So it's very important that you have that in your contract. Honestly, if you're any kind of business that has a reservation of date or a reservation of your fees, make sure that that's clear. And then offer interest-free monthly payments all the way through to the end of your performance of the contract. The great thing about that is it creates a nice, beautiful cash flow for you and your business. Instead of like busy season, ending season, you have beautiful, nice, even cash flow. It's great for loans. It's great for, banks review that more positively. And then in the wedding world, we make all of our fees due at least 60 days prior to the event day. That way, if there's any discrepancies or anything is running late, you have a lot of time to have that out with your client before the actual event day. You're not expected to do anything else until everything is paid. Make sure to always include return check fees, late fees, etc. Make that very clear in your contract as well. I love this one. You want to cancel. I mean, it's just the most dreaded email, phone call that you want to receive. Your inventory, remember, they're your wedding days, so make sure that you protect them correctly. Your cancellation policy needs to be very personal. This is the one that we prefer at my wedding venue. I'll just read it to you. The client may cancel this agreement upon notice in writing by the signer of this agreement delivered to Maison Albion LLC. The client will forfeit the entire reservation fee to cover lost revenue, costs, and expenses If Maison Albion LLC is able to lease the venue to another customer on the event date, the client will receive 50% of the reservation fee. If the agreement is canceled within 180 days of the event, the entire balance of the agreement is due by cancellation. Oh, to farm one to 1750. Oops, that's another client I didn't put this in for. So just saying here that like if you're able to rebook the day, replace the inventory, then you're compensated by at least half of the reservation fee of what they paid so far. And that helps you cover remarketing costs to resell your services to another client. It also gives a little bit of flexibility to the client to say like, wow, okay, if I do cancel and they're able to rebook, there's a chance I could get some of my money back. Again, it's an awesome marketing tool. Remember, that's what your contract can do. And it can also, help with that bottom line and make sure that your cash flow stays uneven so you don't have a shocking cancellation that affects your cash flow so severely. What about rescheduling? So if you have a client that originally booked you for a certain serious time or a date, again, this is a personal decision, but this is what we recommend. We charge a flat fee of $1,000 for a rescheduled date. And we only allow that as long as it's at least 6 months prior to the original event date, because it allows enough time for us to remarket that original event date. But also, most clients who are rescheduling are scheduling year over year. It's usually like pregnancy or death in the family or something like this. This allows you to compensate for increases in pricing, inflation, year over year, changes to any other services that you provide. And it's also a very reasonable rescheduling thing. A lot of venues and services don't allow rescheduling at all. So again, this is another marketing opportunity for you. It's for us, with 110, 120 event days a year, it's probably only used like once every 2 to 3 years. Very rare. Again, it's just a great marketing tool to have in your contract there to show again that you're a reasonable person and want to allow them some flexibility. It's life and these are big events, so that's important. Client designated representative is a really great clause to have. Say for example, running through the day, your DJ is late. Do you want to bother the groom? It's pouring rain. Do you want to bug the bride? If you offer in your contract that you require a client designated representative that's allowed to make legal decisions for the client on their behalf on wedding day, you don't bother the couple themselves with their wedding day, but it allows you to make changes on the fly that are sometimes required, like moving where the location is or having to replace a vendor. Very important. It's a really great clause. Let's talk about protecting them and protecting yourself. This is the clause, of course, that everyone was missing during COVID because we'd never lived through a pandemic and we didn't know that we needed these kinds of clauses. So this is really important to have. We typically refer to COVID now as government restrictions on attendance. So, for example, if Maison Albion is unable to provide venue services booked by the client due to government restriction on attendance, the client may change their date to any other date with no additional fee. Again, a great marketing tool. It's highly unlikely, knock on wood, that we go through another pandemic in our lifetimes, but this allows you, again, a great flexibility, showing you're a human, a marketing opportunity to show that if there's something happens with, government restrictions, that you have flexibility at no cost to change your date. This is also a clause that I highly suggest you have. Give yourself the opportunity to cancel a contract. This works for every contract, but at any time with full refund of fees to the client. This serves as the limitation of damages that can be sought by the client in case of cancellation. This is really important. We call this the kindness clause in our contract. This is in case of you work with a client for a period of time and there's someone that comes out of the woodwork there you just can't handle, like red flags all over the place, really difficult client to work with, or maybe it's the client themselves. This allows you to cancel the contract and completely refund the fees to the client because no performance on your part has taken place, or very limited performance on your part has taken place. And it seeks to limit the damages, so they can't come after you for emotional damages or anything like this. In case of cancellation. Also, consider a military clause that allows complete flexibility in the date in case of someone being called up, and if they're in the military, if they're in the reserves, and they're deployed, and it gives them full flexibility and protection to change their date. That's just a great kindness. Again, an excellent marketing tool, but very rarely used. Make sure that you define very clearly what's included. So are you setting up and shutting down and handing over the keys? What inventory is included in your services? I also think it's a great idea to require event review meetings. When are they happening? 6 months, 1 month? Are vendor meetings required? Just make sure that's all clearly defined in your contract. Event decor is really important. So as you know, event decor, gorgeous as it is, can do a lot of damage to your property. So make sure that you clearly define what can and can't be used. So can command strips be used, fire lanterns, cold sparks? None of those are allowed at our venue, but if you do allow them, make sure it's clearly shown. Are you allowing open flame, or you only allow flame within glass, or no flame at all? Make sure that if you allow sparklers, that you require that buckets with water are there, and how many buckets of water are required so that they're easy to distinguish. As people who have been cocktailing and fire never really mix very well. How are balloons to be handled at the end of the evening? Do you allow glitter, confetti, or birdseed? We don't. It's all awful. Organic materials versus non-organic outside. And make sure that you're very strict about not allowing anyone to use ladders on your property. I don't care what kind of business you are. Do not ever let anyone use ladders on your property. You need to put signs on your ladders that say, unless you're an employee of my business, you are not permitted to use this. They're just huge amounts of liability, and courts often find that if you have a client or a vendor use a ladder in your property, they fall off that ladder, that you are liable for their damage. So make sure that that's very clear. Cheers! Liquor policy. This is obviously the touchiest and scariest part of owning a wedding venue or working in the hospitality industry. Make sure liquor policies are very clearly defined. If you're a non-liquor licensed venue, make sure that you have a bartending contract that's ready to go, or your preferred bartending contract, a service that you recommend. If you're a licensed venue, make sure all of your requirements that they gave you in your jurisdiction are very clearly defined in your contract. Not only will the liquor board require it, but probably your liquor liability insurance will require it as well. And be careful about obeying your liquor permit if you are permitted. One slip could cost you your license, and you all know how expensive that is. So make sure it's very clearly defined and followed by all your employees and staff as well. Let's talk about some additional conditions. So make sure that the place to add in everything that may include the kindness clause, like we had talked about, be very clear and upfront in your contract, like you will not tolerate violence of any behavior towards your staff, aggressive behavior, aggressive language, and that it clearly shows what you will do in those cases. So for us, we will stop the event and cancel it. We don't tolerate any kind of violence of any kind. Make sure that you have a restorations and repairs clause. This is a general broad sweeping clause that allows you to make changes to your own property, your own services, your own place of business without the approval of your clients. If you are in a rural farm area, make sure that you clearly define that in your contract and let them know there may be smells, sights, sounds that are associated with being in that area. How are you handling smoking of marijuana? Make sure that's clearly defined for you. Also, how are children's and pets handled on your property? Are they permitted? If they are, what are your limits to supervision, or what will you do if children or pets are unsupervised? Clearly state that you don't allow fights or weapons on your property if you don't allow weapons. If you have a requirement for event insurance by the client, make sure that's clearly defined and what those limitations of liability need to be. We recommend $1 million per occurrence, $2 million aggregate, and then add your business specifically with the mailing address as the additionally insured on the insurance. The reason why event insurance is so important is that it not only protects your property from all the excessive damage that their guests can do to your property, it also protects their investment in the business. Again, this is another marketing thing to say, I'm thinking of your investment in this, and it's typically only $150 to $300 for an investment of $30, $50, $80, $120,000 of a wedding. So it's really important to have, even if venues don't require it. And then make sure you have an inclement weather clause, which just says you're not liable for inclement weather, which is obvious, but it should be in your contract as well, and that you don't offer, refunds in case of inclement weather. Make sure that you have a photography clause. You want to make sure that they have an automatic model release in your clause so that you can use their photos and videos for your marketing purposes, social media, website, and then also include other vendors' ability to use photo and images too, so that you're not in trouble for sharing it online and then another vendor shares it. Indemnification and release of liability is important to have as well. This is standard for any agreement. But you want to make sure that you protect yourself from harm that can come from your clients, your guests, and be specific of all of those items things that could happen to them. The slip and falls, tears, cracks, things can happen to them. Make sure that to include the clause again, if you have a different LLC that owns your property versus the one that is the business. So again, going back to those terms, maybe my third slide, if you have a different LLC that owns the property as the owner of the property, you want to make sure that's clearly defined in your legal terms, and then re-reference it again here in your indemnification and release of liability, so that not only the LLC that runs the venue or your business is protected, but also the LLC that owns the property that your clients are attending or there. Here's some potential habits, insect bites, drowning, snake bites, injuries from falls or tripping, interactions with wildlife, serious bodily injury, permanent disability, paralysis, and loss of life. Oh, and you just thought we were going to a wedding, but you want to make sure you protect yourself. Again, this is all about protecting you, yourself, and your family. So outlining those terms correctly is, something that, God forbid, you end up in court one day. You're well protected there. So your choice of law and jurisdiction, make sure that you also have your retaliation clause in there. Select a jurisdiction that's convenient to you. So just know what county you're in, obviously you too, state, etc. Make sure those are clearly defined as your choice of jurisdiction. Most courts will honor this clause because the majority of the contract took place in that jurisdiction. There's not a lot of argument against honoring that jurisdiction. It's just more convenient for you, less legal fees, etc. for travel. Retaliation is a clause that's important to have. It's difficult to enforce, but you need to make sure the client and its agents are aware that you exist. So it's basically just a clause saying, please don't disparage me online. Please, let's communicate professionally with each other. But it's pretty nearly impossible to prove or enforce. But you could, use it in the case of a cease and desist if you have someone that just goes off the handle against you online. Force majeure clause, en français, it means greater force. Just remember it's performance. Like, it's all about the performance part of the clause. It releases you and the other party of performance if there are outside named forces that prevents either of you from performing. So your force majeure clause should say, like, in the case of a hurricane, terrorism, flood, acts of God is where you see this a lot. It relieves both of you from liability. It doesn't mean that you won't perform, but it just means that, like, neither of you can sue each other if a hurricane rolls through on wedding day. You can sue each other, but you will unsuccessfully sue each other. Four corners is a great clause to have. Essentially, it's just the four corners of the contract, like a page. It's just saying that everything has been agreed upon is in the four corners of this contract. It protects you from anything that might have been said on a site tour, sent in an email or text. It also limits your liability for email communication. It specifically should state that any amendments made to this contract need to be signed by both parties and are amendments to this contract, as opposed to saying, like, you'll honor and say everything. Again, you're a human first. If you email the client and promise them something and don't deliver, that's your choice to actually deliver on that. But this contract protects you from your failure to perform in the case that you send them an email and you don't perform with what you've promised. The waiver clause also allows you to be a human. So if you decide, for example, they move their date and you don't make them pay that $1,000 fee, that doesn't invalidate the rest and the entirety of your contract. So saying, oh my gosh, your mom passed away, of course you don't want to celebrate this week, let's move your date, and I will happily waive that $1,000 fee, and I'm so sorry, my condolences. But all of the rest of the contract that we've signed together is still valid. So it doesn't reduce your ability to enforce the other pieces. Okay, and then we get to the good part, signing on the dotted line. Of course, it's your personal choice, but I do recommend only having one party sign the contract. You have to go all the way to the worst case scenario on this one. If they cancel, you're not stuck between two parties fighting and saying, I paid the deposit and this person signed the contract. I'm sorry, it doesn't matter. This is the party of the contract. Your job is to make sure that person is the only one that's allowed to cancel, make amendments to the contract in case of cancellation or the fact that they might break up. Electronic signatures are valid in all jurisdictions. So that's important to know that, all of us use like CRMs online and they're fine. Well, I hope this is a great introduction to building contracts with confidence. If you need more help from me, this is how you can reach me at nowweflourish.com. I would love to help you write your small business contract. If you need assistance with that, you can reach me there, and go forth with confidence. Have a great day.